without prescription, random UAs to confirm, maintain gainful employment, or show proof of performing 8 hours of community service work each month that he is unemployed. Currently, Mr. Payne is employed, so that's not really a concern, but I just wanted, it was a little different than what we normally put on here, so I just wanted to make sure the court didn't have any questions.
Yes,
And I have completed the score sheet, just marking it with the 1 year of probation. May I approach?
Granted. Raise your right hand, please, Mr. Payne. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you put your hand down. Now, you heard what Ms. Jaquith said, and you signed the written plea form.
Yes, sir.
How old are you?
46.
How much school do you have?
3 years of college.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read in the plea form, what Ms. Jaquith just announced to me.
Yes, sir.
Do you understand you're pleading no contest to the announced charges,
Yes, sir.
waiving your right to a trial by jury?
Yes, sir.
You'll be adjudicated guilty, be placed on a year of probation with the conditions that were announced, and the fees that were announced. Is that what you understood?
Yes, sir.
All right. Ms. Jaquith answered all your questions about the plea and how it affects you,
That is correct.
and you're satisfied with how she's represented you?
Yes, sir.
Now, you understand one of the things that's being done today is withdrawing the motion to suppress.
Yes.
And obviously, Ms. Jaquith's told me that she's chatted with you about that, and by making this plea, you're withdrawing that and giving up forever your right to challenge the state's evidence based upon the way Ms. Jaquith wrote your motion to suppress. You understand that?
Yes, sir.
Okay, and you're willing to do that based upon what she's represented to me in this plea agreement?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea. You can step over this way, please.
Your Honor, I do have 2 matters on the docket. One is in custody, but he's in prison. He won't be here.
The correct score sheet for Mr. Payne, I don't know if you...
Oh, I provided him the one that was in discovery.
Yeah, this is the correct one. That's accurate.
Your Honor, if I can just have a moment, because I'll need to fill this out, and then I'll approach and provide it to the court, unless if the court wants to pause while I do it now,
Yep.
if that's okay. I just don't want to waste the court's time. Whatever it was. Your Honor, I was just explaining briefly to Mr. Payne just what the change was, and I had talked to him briefly about it yesterday, so. May I
So
approach?
that one's correct?
This is the amendment. And I have to fill this one out for the record, with the 1 year of probation.
All right, very good. All right. Thank you. Good day, sir.
All right, thank you.
Your Honor, for my morning docket, I have Tyree Washington, 10 CF 567.
Yes, ma'am.
Your Honor, this is a request for a resentencing hearing for a juvenile who's sentenced to life. I'll be completely candid with the court. Mr. Washington was resentenced in 2021 pursuant to an order from the Florida Supreme Court, and he's asking for a 15-year sentencing review. I need to do some additional research to find out if he's even able to have that at this point, since he was just resentenced in 2021.
Well, and please approach.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
And I don't believe that defendant is with us, correct?
He is not, Your Honor. He's still in custody of DOC,
And
which I
it's your
made.
intention to do that until you need direct access to him?
Correct, Your Honor. So the jail doesn't get angry with me. I know that they will be upset with us for trying to hold him for, 6 or 8 months. I'd rather at least be caught up to where I can actually have an intelligent conversation with him and then do a
Absolutely.
motion in order to have the court house him.
Just let me know when that time is right and we'll take care of it.
Thank you, Your Honor. Your Honor, I have another kind of weird situation with Mr. Watucky. Well, it's not really weird. Mr. Watucky is on the docket, 24 CF 2710. That case should be falling off and going over to the mental health docket. He has come back to the county jail and has entered into the Bridgeway program. And Ms. Myers did let me know yesterday afternoon that he, although he's only been there for a week, he is doing very well and seems to be very engaged and looks like he's going to be very successful. So this should fall off and go to the mental health docket pending conclusion of his completing that Bridgeway program.
All right, so we should nevertheless set a status date, right?
Yes, sir. So
it
I was.
doesn't fall between the cracks.
Yes, and I honestly anticipated it falling off before today, just hadn't happened yet. So if we could just set this for the first September date, it should fall off the docket.
Madam Clerk?
I believe that's the
September 24th, Your Honor.
All right. Status on 9/24.
Okay. And I'm also covering for Mr. Cobb, so I'll wait until the inmates are
All right.
ready to go.
And then we have one fellow back there. Yes, sir. Come on down. What's your name, please?
Charles Salis, sir.
Say again?
Charles Salis.
Sailor?
Salis, S-A-L-I-S. I have the case number.
All right. Go ahead, sir. What is your case number?
26 CF 1516 F.
All right, give us just a second.
Yes, sir.
Mr. Salis, could you repeat your case number for me?
26 15 CF 1516 F.
1516.
It was two separate cases, but they put it into a new case when they transferred it from the Division 1 to Division 2.
Okay.
I have those two also.
Do you see that, Madam Clerk? 2026-1516.
Yes, sir.
Yes, Your Honor.
And 2 probation, 3 probation.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Oh, not cool, bro.
All right. This is about trying to find the documents and being sure everything is right, and we can't find your new case at all.
I have the old case numbers also.
Yeah, we see that one, 24 CF 1091, and that's the case that seems to be on the docket today.
It should be one more to a 22 CF. They were turned in at the same time.
Yeah, I see the 22 CF 1456, correct?
Yes, sir.
And then you say there's another one?
The 24, then it's 24 10 91C.
But then the 26 case, I don't, granted.
They need to do something.
Correct. Correct. And both the 24 CF 1091 and the 22 CF 1456 are the motions, but I don't see the 26 case at all. So what's probation's position on the pro se motion to terminate, and what's the state's position?
He's not even at his halfway mark yet, and he's labeled as a violent felony offender. We don't recommend early term on VFOs.
Sir, may I say something?
Yeah, just a second.
Yes, sir.
Yes, sir.
My actual probation officer, she recommended and she said that she would be in favor of it, my Officer Brandt. And she's the one that told me that I was over the 50%.
It was 36 months in January of 25. So So I guess my only concern is what is the new case you're referring to?
When on the notice to appear to come today, they put that 2026 case number is what they had on the notice to appear. I have it on my phone.
All right, well, show it to Mr. Snell so he can see what you're talking about, because when you gave that case number, it sounds like it's a new case, but we can't find that case number anywhere. Mr. Snell, would you look and see what he's referring to? Because if there is a new case, of course, that changes what the court would view the request to.
Your Honor, would there be a new case number assigned if they transfer a case from the north end to the south end?
Stepping in the Wayback Machine, I would say no, that should never happen, but under current protocols, I have no idea. They may just have decided to create a new case number and.
In Veterans Court, we'll bring a case from a different county, and they send the whole file here, and then when they assign a new case number for our county, I didn't know if it was something like that.
Well, it shouldn't be, because that's the reason it's called a UCN, Uniform Case Number, and it's supposed to stay with the case throughout the whole.
Because the charge they have is the exact same charge from 1091, from 24-1091.
Okay, so that would be the court's concern. If there was a new case, then that would give the court concern about whether to terminate probation or not. But the court reviewing the progress docket, every one of these charges, although significant and serious, adjudication was withheld as part of the plea arrangement for the 36 months of probation. And it appears from the review of the progress docket that nothing has happened in the case since the orders of probation were filed. There's no reports. I don't see any. It looks like as far as costs, his costs, at least from the clerk's point of view, are all zero. Yes. All right, so Mr. Snell will reach out and provide an order. What I'm going to do is I'm going to simply set this for a status, because I don't want, if that doesn't happen, I don't want this just to slide and not have another court date so we can resolve it one way or the other. If you get the order, then you don't need to be back in court the next time. And as you can see, there's some confusion about getting these cases set and being certain that the timing is correct. So, Madam Clerk, let's choose, we're going to use September 24. Hopefully that'll give more than sufficient time. If you receive that order terminating probation, before that, then you'll know you don't need to be back. Okay? But in the meantime, you remain on probation. You're going to have to still report and comply with the terms and conditions until you receive that order. Okay? All right. So 924, and let's be sure we add that second case number to the progress docket. Okay? All right. Thank you very much. Good day. Charles, we ready?
Mr. Silence.
All right. Mr. Patel, you got some clients?
I do have one client, Judge.
All right. Who is that, please?
Brandon Punton, 26 CF 540. Jay Patel on behalf of Brandon Keith Punton, 26 CF 540. We're before the court on a motion to reduce bond. In speaking to the Assistant State Attorney assigned, we've come to an agreement. Assuming the court is in agreement with our agreement, the agreement that we have come up with is $3,500 account for a total of $42,000 cash professional, a GPS monitor to be attached prior to release at $1 a day, no internet or internet-capable devices, pretrial services, and no unsupervised contact with minors. May I approach with the proposed order?
Yes. And you've reviewed the proposed order and find that acceptable, State?
Yes, Your Honor, I have.
So ordered.
Thank you, Judge. May I be excused?
Yes, sir, Mr. Patel. Thank you. Good day.
And I just, do I need to contact pretrial services?
No, they'll be provided a copy of that.
Okay. Oh, well, is pretrial services the one that attaches the monitor?
Correct.
Okay. All right, very good. Thank you.
Mr. Rare?
Thank you, Your Honor. For the record, David Rare. Coming back to Mr. Ricky Valadares, 24 CF 2354. And this was a petition to expunge. And for speaking to the state earlier, Mr. Snell, I don't believe the state was calling witnesses today.
State intended to reverse or demur the petition.
This is the expungement, correct?
Correct.
So what happened last time was I had a note from my victim advocate that the Sheriff's Department had an objection, and they didn't wish to have someone, they just wanted me to convey what the objection was for the court. And that's the reason that we had to continue it today, so that I could have a chance to provide them an opportunity if they wanted to be here. So the sheriff was just, the fact that it was public funds, he objected to it being expunged, and he didn't feel like that was a good look, but that's all he wanted me to convey to the court. So that's the only position that we have. I don't have, as far as a legal argument to block or to prevent that from happening, the court from doing that. I don't have the grounds to do that.
And I think based on case law with no additional evidence provided at the hearing today and only attorney argument, that would not be enough but for the state to overcome the presumption by law that he's entitled to the expungement.
And I had to discuss that with counsel from the sheriff's department. So.
All right. Granted, do you have an order?
I do.
So absent evidence, the court doesn't have the ability to deny the motion. And of course, you know, that's the reason I set every one of these 4 hearings, just for that reason, to give the state the opportunity to discharge their constitutional obligation.
Thank you.
Thank you very much. Good day.
Thank you, Your Honor. That's all I have. We have one inmate. I think Mr. Appel is going to handle it right today.
Okay. All right. Very good. Thank you, Mr. Rare. Mr. Lupella, who do you have?
Mr. Sean Sasser Williamson. Good morning, Your Honor. Sean Lupella for the record. Mr. Sasser Williamson is before the court on a violation of probation. He's going to enter a denial.
This is 23 CF 411, 23 CF 381, and 26 CF 572.
Very good. He's entering a denial as to the violation. We ask that it be set in 30 days or so for status. The basis of his violation is a new law violation, which is a misdemeanor charges. There was an issue regarding a premature entry of a plea that he wasn't properly advised on. It was a different attorney. In order to be effective counsel, I need to file, and I did file a motion to withdraw the plea. I think the hearing's on Monday. So we'd ask to continue this case, like I said, set it for status, and then in order to be effective counsel, we'll go through that process, and then we can reassess where we're at with the violation.
All right. Now, I actually showed the denial was already entered, and so we'll just set it with no subs on 9/24.
That's prudent, Your Honor. Thank you.
All right. Thank you now. Anything else, Mr. Lupella?
That's all I have, Your Honor.
All right. Thank you now. Good day. Mr. Garrett.
Your Honor, Chris Garrett on behalf of Michael Sfoley and Topoulos 25 CF 1712. I have a signed plea and sentencing agreement here. The count 1 is going to come down to a misdemeanor. He's going to interchange a plea on that, enter a plea of no contest as well to misdemeanor driving under the influence. There's an added condition, just to explain to the court, that he pays $17,000 in restitution. That is to be paid through JCS probation. $8,000 is due within 7 days of the plea. The remainder to be paid within 12 months at a rate of at least $750 per month. If I may, actually take a picture. If I may approach.
Granted.
Thank you, Your Honor.
Thank you.
Have a good day.
Your Honor, I am Mr. Cobb now.
All right.
And Your Honor, for Mr. Thompson's benefit, Mr. Cobb had a family emergency requiring him to leave town at the last minute, so he couldn't be here today. Mr. Thompson's case numbers are 22 CF 1938, 23 CF 1214, 24 CF 1824, 25 CF 1196, and 26 CF 579. Mr. Cobb informed me that he has adopted Mr. Thompson's motion to withdraw plea, and he's asked that it be set for a hearing with subpoenas in September.
Ms. Jaquith, I'm sorry, you said
the motion to withdraw the plea, he wants to settle with subpoenas?
Yeah, my understanding is that he's adopted that
Right,
Mr.
right.
Thompson's previously filed motion, and he'd asked to have it set for a hearing with subpoenas.
With
Yes,
subpoenas,
please.
that's fine.
Just sometime in September, whatever is convenient for them.
Because I wasn't gonna object to it.
Okay, well then it might be prudent to reset this for next week.
That's fine.
And
If-
let Mr. Cobb be here so he can speak with Mr. Thompson before we, again, hog up a afternoon docket that's not necessary.
All right, set it for status on 8:20.
Yes, thank you, Your Honor.
Okay.
So you'll come back next week with Mr. Cobb? Okay, the state's saying that they're not gonna object to you withdrawing your plea, but then your case will start over, so Mr. Cobb will come and speak with you. And so before we formally do that, since I'm not gonna be your attorney, I want Mr. Cobb to speak with you and explain that to you so that you guys can make a decision, okay? So you'll be back next Thursday at 9 AM, okay? All right, and I'll text Mr. Cobb and let him know right now, okay? Thank you, Your Honor, I appreciate that. And that is all Mr. Cobb has on the docket today, and all I have on the docket, if I may be excused.
Yes, ma'am. Good day.
See you this afternoon or this
Yes,
evening? At the bar meeting, Your Honor?
Yes, ma'am.
Thank you.
Yes, ma'am. Mr. Gilbert.
Morning, Your Honor.
Good morning, Mr. Gilbert.
Mr. Nix. Good morning, Your Honor. Michael Gilbert on behalf of Christian Devontae Nix in 22 CF 1063. And we were here on to answer for FTA. He's not here to offer any excuses, but uses this as an opportunity to get it right. He's retained counsel, and we have negotiated with the state to resolve this charge, and we'd like to set that for a plea on the 20th.
All right. So change of plea on the 20th.
Yes, Your Honor. And is there a PM session there? On the 20th, I've got court in the morning in Walton.
Yes, sir, there is. It's kind of busy, but so 2 p.m.
Well, let's set it for 9 if it's busy, and then I'll make it work.
All right. So we'll set that for change of plea on 8:20 at 9 a.m.
Thank you, Your Honor. That's all I have.
Your Honor, looks like this case was last set for a felony arraignment, and we don't have a not guilty plea. Does that need to be addressed today?
Yeah. Waive formal reading and enter not guilty plea.
Very good. Please not, no contest, or correction, not guilty as charged, waiver arraignment.
All right. Thank you very much. See you on 8:20, 9 o'clock. Mr. Weaver.
Yes, sir. I have Tyler Shaw, who's a law.
I don't have anything for the rest of the hours.
Your Honor, I'm here on State v. Tyler Shaw, 26 CT 224.
That's exactly what happened last time, right?
Yes, sir. Yes.
Any, please approach.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton.
Requesting the court set this for status on September 24th.
Status on 9/24.
State agrees with that. Thank you.
All right.
Thank you.
Thank you. Good day.
Good day.
Yes, sir.
And do you have Adolph Thompson?
Your name is?
James Ray Tatum.
All right. Mr. Tatum, you're here today without a lawyer. Do you want a lawyer to help you?
I'm just coming for a show cause.
Say again?
Coming for a show cause on probation.
All right. Well, same question. Do you want a lawyer to help you, or you want to just see what the state has to say first?
Yeah, I can use a lawyer.
Say again?
I can use a lawyer.
Okay. Because I think the notice, the VOP says, let's see. The VOP says you failed to pay your costs and your fees. And the probation is, saying that your probation should be extended 2 years, and that your probation should terminate on the payment of your outstanding fees and costs.
Yes, sir.
And I think your outstanding fees and costs are $765. Your restitution was paid, and they indicate that that was paid as a result of, there was a forfeiture of some inheritance, I believe.
Yes, sir.
And the outstanding cost, $765. And there's, gosh, $5,000 cost of supervision. What does the state wish to do?
Judge, the state's offer would be to extend for 2 years to pay with the auto termination upon completion of payments as recommended by probation. We'd also ask that if you were to accept that, to waive the cost of supervision and arrearages.
That's right. You willing to do that?
Yes, sir.
Okay, so we'll do that as a modification of the probation. We'll waive the cost of supervision, extend the probation by 2 years, which can terminate automatically on the payment of the $765 in court costs plus any surcharge.
Yes, sir.
You willing to do that?
Yes, sir.
Raise your right hand. You swear affirm to testify truthfully in this matter under penalties of perjury.
Yes, sir.
All right, you put your hand down. You heard that discussion, and that's what you're willing to do in return for the modification.
Yes, sir.
Okay? And so with the modification, the state would dismiss any VOP.
That's correct.
Okay?
All right.
I talked
Thank
to
you,
probation before you leave.
All right. Go to, when you say call probation?
Well, they're sitting right there, so just chat with them before you go. Okay?
You said VOP is dismissed?
VOP is dismissed, extended 2 years, cost supervision, any arrears are waived, automatic termination on payment of costs. Ms. Yeski.
Good morning. I'd like to call a couple from the gallery. First, Gussie Roundtree. This is in case 23 CF 1212. Ms. Roundtree is here on an alleged violation of probation. For the court's awareness, this is a financial violation only. It's restitution and court costs. Ms. Roundtree, just for the court's awareness, had a stroke. We have the medical records showing that, as well as a doctor recommendation to not work. Haven't really heard.
What we discussed would be fine with the state to go ahead and just unsuccessfully terminate her probation and send the cost to, and the restitution to Judge Arlene.
I would not advocate for a violation of probation in this case. I would advocate for extending the probation similar to the case just right before us previously, extending for 2 years to give Ms. Roundtree the opportunity to pay those costs. She's not able to work right now.
No objection.
Realistically, what's the chance that she would be able to?
I have a hearing coming up for my disability, so I will not be, I'm gonna be on disability, so. Just saying.
Otherwise, Your Honor, we can just set this for the next available evidentiary hearing. I don't believe that Ms. Roundtree. Thank you for that time.
You're welcome, Ms. Yeski.
We wanted to be sure that because Ms. Roundtree pled, in this case was a withhold of adjudication, that that would remain. if there is an agreement to terminate the probation.
So in looking at the report, it is financials only, and have you had the opportunity to see the medical records, Mr. Snell?
Physically, no, sir, but she explained it to me, and I understand that that's what Ms. Yeski has reviewed, and I'll take her at it, that's what happened, so.
So you concede that the defendant does not have the ability to make the financials only payment?
She hasn't up to this point, correct.
And you've heard the proffer made by the defendant that it doesn't appear that she will have the ability?
Yes, sir.
Do you accept that proffer?
Yes, sir. Yes, sir.
Okay, the court will make the finding that the defendant does not have the present ability and that this is not a willful violation. The violation is dismissed and the defendant will be permitted to terminate probation.
Thank you, Your Honor.
The outstanding costs to civil lien or collections?
Yes.
Okay. Just, so the outstanding costs will be sent to a civil lien
Correct.
and ultimately to collections. Okay. Next, I have Demetrius Rudolph, 22 CF 2613. This is Mr. Rudolph before the court. In this case, it's a violation of probation based on community service as well as court costs and costs of supervision. I've spoken with Mr. Rudolph and he's assured that he would be able to get the community service work and some payments made if we were to set this off. I would be requesting a continuance to the September 17th miscellaneous date.
Yeah, we don't have a 17th. It'll be the 24th.
September 24th.
Yes,
okay.
ma'am. All right. Status on 924. Keep up the good work and see you then, okay?
Yes, sir.
All right. Thank you now.
Are we continuing the arraignment?
Enter a denial.
And that's all I have for the gallery.
That's going to be August the 24th, correct?
No, 9/24.
September.
Judge, there is a Ricky Simpson in the courtroom. He's actually on the 1:30 docket for arraignment, but he showed up early. Will the court hear him now?
Yes.
He has no attorney. It's 26 CF 1344, one count of felony battery that has been filed.
All right. And then Mr. Simpson, you're here today without a lawyer. Do you want a lawyer to help you?
Yes, sir.
Are you able to afford one on your own?
No, sir.
Okay. I'm going to give you a form for you to fill out. Fill that out. Turn it back in. Once you do, then we'll give you a new court date. But don't leave until you turn the form in and get a new court date, okay?
Yes, sir.
All right. Thank you.
He's here for his wife.
All right. Mr. McKinney, Ms. Yeski, you can go ahead.
I'm covering for Mr. Cochran, so the rest I have are inmates. I know that the court has a few inmates that are pro se. I don't know if the court intends to call them first. I know that there's a lot of people in the gallery for Elijah White. You're first on the list. Okay.
All right. Yes, sir.
It's going to be Ramos Perez, Julio Ramos Perez.
All right. Good morning. You're Julio Ramos Perez. All right. You're here today without a lawyer. Do you want a lawyer to help you? Say again? Do you want a lawyer?
Yeah.
Can you afford one on your own? Can you hire a lawyer yourself?
No.
Okay. I'll appoint the public defender to represent you in this case.
This is a violation of probation arraignment, is that accurate?
Madam Clerk?
In our system, it shows as an evidentiary, but looking at the hearings, the original violation of probation arraignment had been continued, and it was supposed to be an arraignment, so I believe it's supposed to be a view of the arraignment today.
So we'll enter a denial and ask for a court date to be set without subpoenas.
All right, is there an offer from the state on this case?
Ramos Perez, Julio Ramos Perez.
Yes, it's guidelines, Your Honor. I believe it's 36 months. It's going to be 36.675 months DOC.
36 months. If we could have a court date set without subpoenas?
Yes, sir. 9/24 at 9 o'clock.
And that's going to be this, yes. 36. Gotcha. I'll talk to you, okay?
All right, you're Tony Salazar, is that right?
Yes, sir.
And this is 25 CF 1216. You're here today without a lawyer. Do you want a lawyer to help you?
Yes, sir. I mean, I don't know what to do. I got
All right.
responsibilities on the streets. I'm just trying to go home.
All right. Can you afford a lawyer on your own?
No, sir.
All right, I'll appoint the public defender to represent you.
Yes, sir.
Is there an offer from the state?
The offer, Your Honor, is to be evaluated for drug court.
All right. We'll set it for status on 9/24.
Thank you, Your Honor, and I will work on setting up that evaluation.
All right, thank you now. Good day.
Was that a denial of that?
And that's with a denial, right?
And deny the violation.
Judge, this is Elijah White. He is on the docket pro se in 22 CF 666, 22 CF 667, 22 CF 928, 22 CF 1037, 22 CF 1039, 22 CF 1475, and 23 CF 320. I missed one, 23 CF 956. I'm standing up because I already represent him in the misdemeanor case, which is the reason for the violation of probation, and I'd ask for the Office of the Public Defender to be appointed.
The PD is appointed.
Thank you, Judge. For today's purposes, we'll enter a denial. As I'm handling the misdemeanor, I know that it's set for September 14th in front of Judge Mason, so I would ask for a court date set without subpoenas after the 9/14 date.
No subs on 9/24. And if something happens sooner, then you can advance at any time.
Yes, sir. Thank you.
Okay, thank you.
Yes, sir.
Jamie Potter?
Say again?
Jamie Potter?
Here. All right. Of J. McCotter, 25 CF 78. This is violation of probation. I'm standing in for Mr. Cochran, who is his attorney. I'm asking for a continuance until, I believe there's a mental health court evaluation that's going forward. So I would ask for 9/24 without subpoenas if the court will allow.
9/24, no subs. And I show denial is already entered, Mr. McKinney, so we're good.
Okay, thank you. It's on the docket as an arraignment, but we'll enter denial anyhow.
Okay, we'll double deny. And then I show that we've got, and this is still not resolved, I show 26 CF 728 is currently in front of Judge Clark.
26 CF
728.
728.
And we addressed that when we were here last time, and I didn't know if it was going to be transferred or what, and I just...
Can we, in the interest of judicial efficiency, state his or attendance transfer
This case to Judge Clark?
No. 26 CF 728 into this case to track with this case, Sean, as we do have the lowest case number.
Not with the case, but into the division?
Correct.
All right, Madam Clerk, what's the status of the 26 CF 728 case? Do you see that?
I'm looking for
Is that also a violation of probation? As we're talking about, you come on over.
I see that looks like it was a VOP, the VOP warrant issued in July. There's supposed to be a pre-trial conference actually yesterday, but it was canceled because he was previously sentenced. Looks like the 26 CF 728 case is being addressed in mental health court.
Did you hear that? According to Madam Clerk, the 728 case is being addressed in mental health court.
So it's actively in mental health court? Are you in mental health court? So we would withdraw our words in this motion to transfer this case into this division. I think what Mr. Cochran is likely doing is trying to see if he's going to be allowed to stay in mental health court given this violation.
But I guess we probably should say that the 728 case should be reassigned underneath to us so that if there is, we don't want two judges supervising even if it is in mental health court. Does that make sense? I'm just not sure. What I don't want to happen is if there's an issue on the 728 case, he'd go back to Judge Clark and have a conflicting disposition for what we're doing here.
The concern from the defense is that if we did that, if for some reason he's taken off the mental health court docket, if we reassign it here, we just have to make doubly extra clear that he stays in mental health court on that docket too.
Yeah.
Understood. So.
I feel like we would need to write.
All right.
I feel like we need to write a pretty detailed written order basically stating that it would, I don't know how to word that, but essentially that if he does get removed from mental health court, it comes back to your docket as opposed to going to Judge Clark's docket.
Correct, and that would be for the, and Mr. Bricato, this is because I don't like anybody getting in a loop, right? I don't like anybody getting lost. I don't want their cases to get, it should be consistent, and that's the reason. It's not about you individually, it's about being certain that the case is run effectively. So, I guess what you can do is just, you can reach out to Madam Clerk after it's over, and with Mr. McKinney, you can, or Mr. Cochran, you can just say, how do we do this? Because I agree, what we want to be sure is that he's got one judge for the cases that are running together. That's only fair to everybody involved in the process. The last thing we want is to have an evidentiary hearing set and everybody get ready, and then one of us go, well, wait a minute, this is not fair, we should have two proceedings. So however you need to draft the order to be sure that it says he stays in mental health court, but the underlying case, should it come out of mental health court, needs to be reassigned to this division. I'll sign the order, whatever you think it needs to say to be sure it works out, because we don't want to upset his mental health court assignment either.
I'll communicate that to Mr. Cochran and discuss that with the state and the clerk. So if we just have 9/24 for our next court date here, unless that comes off because of mental health court for some reason. You should.
McGee's?
And Judge, I'd asked for Matthew McKerney to be heard at 1:30 with his other case, so that Mr. Cochran can be here. This is Mr. James McNeese.
This is McNeese?
Correct. Did you hand back a plea form?
And this is 2628, correct?
Did you send back?
This is Mr. McNeese.
This is actually,
2005 CF 240.
this is 4605 CF 2682.
Okay. I'd handed back a plea agreement, but he hasn't seen that yet, so I'm going to hand him another copy. And if we could call him back in just a minute, then we should be ready to proceed
All
with
right,
the
so
plea.
this, and once again, this is James McNeese,
I believe it's
2005 2682.
correct. 2005 CF 2682.
All right, very good.
So we'll need just a moment for him to read the agreement and call him right back in.
Can you stand right there, Charles? All right, let him stand right there. Let's keep things moving. Who's next, please?
Angela, I'll defer to court security.
Miller? Angela Miller?
And you're waiting on medical records for
I don't know if we'll get it back there.
Sure. This is Angela Miller in 26 CF 677. The defense is seeking medical records to show that she was in the hospital for a period of time, and that will change the position with the state. I'd like to come back on the next available, I believe that's next week, for the violation of probation without subpoenas.
All right, so 820, no subs.
Thank you, Judge. If for some reason Mr. Cochran does not have those records by then, I'll notify him to notify the state and court. Sure. Okay.
And after Mr. McNeese, we're going to take Mr. Simpson. You can come on down and wait, Mr. Simpson, here. You'll be next, okay?
We've had a chance to read this over, right? lost the other one. Good thing I printed a copy. I got it. Mr. McNeese, before the court in 2005 CF 2682, which is to admit the violation of probation. He will be adjudicated guilty. Be served 9 months Okaloosa County Jail. That will revoke and terminate the probation. That jail sentence is with credit for time served, and it includes an additional credit of time spent in custody in Alabama. The way that the plea agreement is written by Mr. Cochran is credit for the 5 months spent in the custody in Alabama. Standard court costs, cost of prosecution, cost of defense. I believe that's just the $100 VOP and $150 cost of defense. No objections to the score sheet. May I approach?
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, and you put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
I
I apologize. You heard what Mr. McKinney said, and you signed the written plea form?
Yes, sir.
All right, you understand that you're admitting the violation?
Yes, sir.
And that tells me, yes, Judge, I violated the way the affidavit report by my officer says it did.
Yes, sir.
You understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
In this case, you'll be adjudicated guilty if you were not previously. You will be sentenced to 9 months in the county jail, credit for 5 months spent in Alabama, plus any time you've spent here. You'll have $100 cost of prosecution, and $150 state-provided legal assistance, plus whatever your outstanding costs were from your probation. Is 2 years sufficient time to get that paid?
Yes, sir.
All right. And Mr. McKinney answered all your questions about, or Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
Satisfied with what they done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Yes, sir. Have a good day.
Mr. Simpson. All right, Mr. Simpson, I've reviewed your form. It appears that you're qualified for the appointment of the public defender. I'll appoint the public defender to represent you. The clerk will review the form. If they say that you don't qualify, they'll tell you why. And if you think they're wrong, then get everything you have that shows they're wrong, give it to your lawyer, and bring it to court with you next time, okay? And then we'll review that, okay? And Ms. Yeski.
At this time, we'll deny the violation if that hasn't already been done.
Well, I think this is an arraignment, I think.
An arraignment, I'm sorry. Still on the night.
Yes, ma'am. Well, he came early, so that's the reason you're confused. No problem. So, waive formal reading.
Yes, we'll waive formal reading. Looks like there's an information if I may approach.
Granted. And this is set for when, Madam Clerk?
This is set for the September 14th.
All right. This is already set for September 14th. So, Mr. Simpson, get in touch with Ms. Yeski as soon as possible because you're set for pretrial on 9/14, okay?
And for the record, entering a plea of not guilty.
All right, very good.
Thank you.
Thank you, Ms. Simpson. Good day.
Yep, we're still trying to figure out the 2026 case. I was looking to see if he was deleted, like if there's like created accidentally after we did, but we're still trying.
I don't see Mr. Snell. Madam Clerk is indicating for Mr. Snell that there are actually 3 Salas cases, and he filed a motion in all 3 of the cases. None of them are a 26 case. They're all 22s.
One's 22 case, one's 24 case.
Sorry, one's a 24 case. That's right, because I saw the VOP in 24 before he went on probation in 25.
What was this individual's name, Your Honor? I'm sorry.
Salis,
Oh, the general.
Charles Salis, who filed the pro se motion to terminate. So there's the 24 case, 2 22 cases, but not a 26 case.
Just the 122 case. So there's 124, 122, and then
Don't listen to me, listen to the clerk. What are the 2 case numbers for Mr. Snell, please, Madam Clerk?
22 CF 1456 and 24 CF 1091.
And there is no 26 case
That we can see.
that we can see. All right. All right, who is this we have?
This is Scott Knowles.
All right, Mr.
Knowles
Knowles,
is
come
present
on.
before the court in 24 CF 2763. There was an agreement already signed by Mr. Knowles and Mr. Cochran. He wishes to move forward with that plea today. The agreement for the admission would be an adjudication of guilt, 14.25 months Department of Corrections with credit for all time served. That credit for time served includes 5.9 months spent in custody in Georgia, and standard court costs, which I believe is the $100 VOP fee, $150 cost of defense. We would ask that any outstanding monetary obligations go to a civil lien. May I approach?
Granted. Now, we were here last time, and I think that we reset it for today because the defendant was not aware, indicated he didn't understand that they would include a sentence to the Department of Corrections. That's been resolved at this point in time. Is that right, sir? And you understand now?
Yeah, I mean, I served my time in the Department of Corrections. I mean, I don't serve in the county.
Correct.
Okay.
I believe that was my kick over today. He does wish to move forward.
Okay. All right. Raise your right hand for me, please, sir. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay. Do you understand by this plea arrangement that you're admitting the violation?
Yes, sir.
That tells me, yes, you violated the way the affidavit and report filed by your officer says you did.
Yes, sir.
Do you understand by making this plea, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
In this case, you'll be adjudicated guilty if you were not previously. Your probation will be revoked and terminated. You'll be sentenced to 14.25 months in the Department of Corrections. You'll get credit for 5.9 months spent in Georgia, plus any time you have otherwise you'll be given credit for. You'll have $150 cost of state-provided legal assistance, and you'll have $100 cost of prosecution. In addition, you'll have your outstanding monetary conditions, and they'll, pursuant to this agreement, they'll all be reduced to a civil lien. You need a minute, Mr. McKinney? All right, is that what you understood?
Yes, sir.
All right. And with this and your little more time, you've had all your questions answered about the plea and how it affects you.
Yes, sir.
Satisfied how you've been represented.
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Thank you.
Sir, have a good day.
Sir.
You're going that way.
Jason, we just got that started yesterday. So
Okay.
it may be prudent to maybe continue this out.
I think so.
farther than April.
Okay, I agree. Judge, this is Elizabeth Newton before the court in 23 CF 1345. She's going to go observe mental health court. I believe she was not able to make the last one because she was not feeling well. But if we could just set this off until 9/24.
9/24, no subs. And if it rolls off before then you won't need to be back, okay? All right, thank you.
Mental health court and see how that goes. Okay. Next should be Cheryl Oglesby. Ms. Oglesby is before the court in two case numbers, 25 CF 587 and 25 CF 1856. Each are violations of probation. She's going to be admitting the violations of probation for an adjudication of guilt in each case. 6 months Okaloosa County Jail with credit for any time served. I'm assuming that is a concurrent sentence.
It is.
There will be $100 cost of prosecution in each case, or a VOP cost, and a total of $250 cost of defense. No objections to the score sheet as provided. May I approach?
Granted. All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay. Do you heard what Mr. McKinney said, and you signed a written plea form?
Yes, sir.
You understand that you're admitting the violation?
Yes, sir.
And that says to me that you do agree with what your officer wrote in the violation report, that you violated your probation?
Yes, sir.
And by doing this, do you understand that you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
And in this case, you'll be adjudicated, these cases, you'll be adjudicated guilty if not previously. Your probation will be revoked and terminated. You'll be sentenced to 6 months in the county jail, credit for time served. You'll have the fees and costs that were announced. How much time do you believe you'll need to get your fees and costs paid once you're released? 24 months enough?
How long?
24 months?
Yes, sir, that'd be fine. Who do I pay for it?
Yes, ma'am. Okay. Mr. McKinney or Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
You're satisfied with how they've been representing you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Thank you so much, sir. Thank you so much. Okay.
Straight down the line. Dennis Hunter?
It is.
Mr. Hunter has been evaluated for the drug court program. It sounds like they are still working through that, so I'd ask that we come back on a status court date next Thursday without subpoenas. It sounds like they're far enough along in that process that we should have an answer by then. Understood.
All right, so status next Thursday.
Yes, sir. And it may drop off. If not, then we'll look at other options, but it sounds like we're going forward with drug court. Nope. If you get sworn in on Wednesday, you're done. You don't come back here. If you don't, then you'll come back here just in case.
Thank you very much.
Thank you, bro.
Walker?
This is Kane Walker before the court. You good?
I didn't mind the pain.
Mr. Walker is before the court in 24 CF 2809. He is going to admit the violation of probation. The sentence that we've agreed on is 9 months Okaloosa County Jail with credit for time served. That will revoke and terminate his probation. There's a $100 BOP fee, a $150 cost of defense. That is a negotiated downward departure. May I approach?
Granted. All right, raise your right hand, please. Say again. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
Yes, sir.
You understand by this plea arrangement that you're admitting the violation?
I do.
And that tells me that you agree with your officer that you violated the way your officer says you did.
Yes, sir.
You understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
All right, in this case, you'll be adjudicated guilty if you weren't previously. Your probation will be revoked or terminated. You'll have the additional fees and costs that were discussed, plus whatever outstanding financials you have. Is 24 months enough time to get those paid?
Yes, sir.
Mr. McKinney answered all your questions about the plea and how it affects you.
That's right.
Satisfied with what he's done for you.
100%.
Court will find the plea to be freely and voluntarily entered into and accept the plea.
I'll pass to Ms. Yusky.
This is Robert Peterson before the court in 20 CF 3190. At this time, we will enter a denial to the violation and would like to set for the next court date, if we could, the September 24th court date. He also has an arraignment in the new 26 CF 1458 case that's set for September 17th. And that case is the sole basis for the violation.
And say again, it's 26 CF.
1458.
Has any information been filed?
Not in that case, Your Honor.
Okay. So you want to go ahead and and when's the arraignment set for that?
September 17th.
Let's go ahead and set this for September 17th, and that
Okay.
way they'll travel together.
Okay, that works. All right. Molly-Yusky.
Yeah.
This is Jason Polgar before the court in 26 CF 917. We have an agreement in this case. It would be to admit the violation, be adjudicated guilty, serve 9 months in the Okaloosa County Jail with credit for all time served, revoke and terminate the probation, $100 VOP fee, $150 cost of defense. Just need a signature.
I also represent Mr. Polgar with a misdemeanor. Would the court be willing to accept a plea to misdemeanor or offense?
In the interest of judicial efficiency question?
As a courtesy to the misdemeanor judge?
Yes.
Yes, Madam Clerk.
Judge, in 26 NM 1972, he wishes to enter a plea of no contest to one count of resisting without violence. That would be $270 in court costs, a $100, I believe a $50 cost of defense because of the application we are in the felony case. And that would remove him from the 914 docket of judgments. We would simply with this court's jurisdiction to handle misdemeanor.
And that's simply time served with the
It's gonna be
cost.
60 days concurrent with the 9-month sentence in these areas. With the adjudication. And that was the offer from the state.
Mark?
May I approach?
Granted. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, and you put your hand down. You heard what Ms. Yesky and Mr. McKinney said on your behalf. You signed the written plea form.
Yes, Your Honor.
All right, you understand by this, we got two things going on. You got the misdemeanor plea, which we're taking orally, and you got the VOP plea, which we're doing in writing, you understand?
Yes, Your Honor.
All right. As the VOP plea, you understand by this plea arrangement that you're admitting the violation.
Yes, Your Honor.
And that tells me that you agree with your probation officer that you violated just the way the affidavit report says you did.
Yes, Your Honor.
And with that, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, Your Honor.
You'll be adjudicated guilty if not previously. Sentenced to 9 months county jail, credit for all time served, revoke and terminate your probation with the fees and costs that were announced. You'll have 24 months to pay your all your costs. And concurrent with that, you're agreeing to plead no contest to the 26 MM 1972 case. Is that right?
Yes, Your Honor.
Do you understand by making a plea of no contest, you're telling me that you believe the state could prove your guilt in that case and you're not going to contest it?
Yes, Your Honor.
Do you understand by doing this, you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, Your Honor.
In this case, you'll be adjudicated guilty, be sentenced to 60 days concurrent with the sentence you're serving in the 26 CF 917, and you'll have the additional $270 in court costs and $50 state-provided legal assistance. And you'll have the same 24 months to get those fees and costs paid after your release. Is that your agreement?
Yes, Your Honor.
Court find that plea to be freely and voluntarily entered into, and the plea on the VOP freely and voluntarily entered into, and accept the pleas with adjudications.
Ruben?
This is Chance Rubink before the court in 25 CF 1515, here on an alleged violation of probation. At this time, we'd like to deny the violation and possibly reset it to next Thursday. I've spoken with the state about this case, and I think we can come to an agreement. We're looking into a potential intensive outpatient program. We just want to make sure that that exists here in this county or in Milton where Mr. Rubing resides. So we'll just need, I think we can get that done in a week.
So status or possible change of plea, is that what we're saying?
Yes, and I believe that 820.
820, no subs. All right, thank you, Mr. Rubin.
Thank you, sir.
See you then.
This is Peter Rybicki before the court in 24 CF 938, 24 CF 2711, as well as 25 CF 13. At this time, and Mr. Rybicki and I have discussed the implications, but he is seeking to admit the violation of probation and request the opportunity to have a sentencing hearing in this case. For Your Honor's awareness, there is a 5-year suspended sentence. We are conducting and waiting on a mitigation evaluation in this case.
All right.
And we would request, could we do the September 24th miscellaneous date for the sentencing?
That's going to be a pretty big docket already. We might want to go to the first one in October.
Okay.
Just because it's going to be a very healthy one. So that will give us, be sure we're not time pressed, and particularly if you're going to have witnesses testify.
Yes.
Okay, so we'll do that. What's the first date in October, Madam Clerk?
October 15th, Your Honor.
October 15th. That'll give you plenty of time, and we won't be crushed for time on that date.
Do we need to go ahead and enter the plea now?
I think so.
Yeah.
At this,
Get a written one.
oh. I will prepare that, and we will, if we could pass this case, I'll prepare the written plea. Yes,
It's an admission with no agreement.
correct.
Okay, sure.
Okay, thank you.
And if you'll hold Mr. Rubicki for entry of the plea, thank you. It was canceled.
Yes,
I just need 1 second for Thank you. This is Kervin St. Jean before the court in 25 CF 2107. We have an agreement in this case. It will be admit the violation, adjudicated guilty, 6 months in the Okaloosa County Jail with credit for all time served, revoke and terminate the probation, $100 VOP fee, as well as $150 cost of defense. It's been signed by all the parties. You just missed the date.
And Your Honor, the state will provide a score sheet here.
May I approach with the signed agreement?
Granted. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury? Is that yes?
Yes, yes, sir.
Okay, thank you. You can put your hand down. You heard what Ms. Yeske said on your behalf and signed the written plea form? And you understand by this plea arrangement that you're admitting the violation? And that tells me that you do agree that you violated just the way the affidavit report filed by your officer says you did. In this case, you'll be adjudicated guilty. If you weren't previously, you'll be sentenced to 6 months in the county jail, and your probation will be revoked and terminated, and you'll be assessed the additional fees and costs, plus your outstanding fees and costs from your probation. Is 24 months enough time to get that paid? Okay. Ms. Yeske answered all your questions about the plea and how it affects you. And are you satisfied with how she's represented you? The court will find the plea to be freely and voluntarily entered into and will accept the plea. And the state does concede that this is a guideline sentence based upon the work they've done on the score sheet.
Hold on, Your Honor.
We need to check the score sheet, Your Honor, before we can answer that question.
believe it will be a guideline square, or guideline sentence, Your Honor.
All right. The court accepts the plea. If you'd step this way, please. He's already been adjudicated, I believe. He was already adjudicated.
Is
Thank
Rebecca
you.
right there?
Good day.
Is Rebecca right there?
David Stevens?
This is David Stevens before the court in 24 CF 2743, 24 CF 2744, 24 CF 2778. It's here on an alleged violation of probation. We are seeking a continuance. I've spoken to the state about this case. We're working on getting confirmation from a residential treatment center. I believe the state announced at the last court date. I think we could get this done by next Thursday, if there's still room on the 8:20 docket.
All right, 8:20, no subs.
Thank you.
Richard Stevens?
This is Richard Stevens before the court in 22 CF 272. This time we will deny the violation and request to set it for the next available miscellaneous without subpoenas.
9:24, no subs.
And just for the record, my understanding is the state is seeking a 30-month DOC sentence with an additional 5 years of sex offender probation.
That's correct, Your Honor.
All right, very good. See you on 9/24.
Thank you.
You ready to recall her, Vicky? You ready to recall her? At least, Vicky's staying right there.
Your Honor, at this time we can recall Peter Rybicki. I may just have Thank you for giving us the extra time. Again, Peter Rybicki before the court, 24 CF 958, 24 CF 2711, 25 CF 13. We have the written agreement, which is just to admit the violation, respectfully requesting a sentencing hearing in this case with no agreement with the state, $100 VOP costs, and a $350 cost of defense. Be adjudicated guilty, and I have the signed agreement. May I approach?
Raise your right hand, Mr. Rybicki. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do, sir.
All right, and you put your hand down. Now, you heard what Ms. Yeske said. You signed the written plea form.
Yes, sir.
All right, and the written plea form provides that you're admitting your violation.
Yes, sir.
And that tells me you agree with your probation officer that you violated your probation the way the affidavit report says you did.
Yes, sir.
And by making this, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
Now, this is a plea without an agreement to any sentence. Do you understand that?
Yes, sir.
That means it's completely up to me about what the sentence would be at sentencing time. Do you understand that?
Yes, sir.
And Ms. Yeske has been careful to tell me that there is a 5-year suspended sentence as part of your probation. The reason she's telling me that is because she knows that it's my view of a suspended sentence that unless there are unusual, extraordinary circumstances, that a suspended sentence should be imposed, because the purpose of it is to essentially give you the power to decide whether you go to prison or not. And if you violate, then it's presumed, it's believed that the suspended sentence will be imposed. The reason I'm addressing that is because Ms. Yeske knows that that's an important part of this proceeding for you to know and understand that it's presumed, it is believed that at sentencing date, you'll be sentenced to the 5 years unless you're able to demonstrate to me, with her help, that there are some circumstances that would convince me that I shouldn't do that. Do you understand?
Yes, sir.
Okay. So, but it's completely up to me at sentencing date on that issue. Do you understand that?
Yes.
And you're willing to go forward with those circumstances?
Yes.
Okay. Now, Ms. Yeske answered all your questions about the plea and how it affects you otherwise?
Yes, sir.
Satisfied with how she's represented you?
Yes, sir.
Now, we're going to set this on 10:15. Be sure we got enough time because the doctor's real busy the next time. And Ms. Yeske's indicated she wants to be able to gather the information necessary to present a good sentencing hearing on your behalf, including some mitigation. So she'll be reaching out to you. Be certain that you are able to provide her all the information she needs to be able to do a good job for you at the sentencing hearing, okay?
Okay.
All right. Thank you now. Good day.
No PSI needed in this case,
No PSI. Right, Ms. Yeske? No PSI. No PSI.
No.
Good afternoon, Mr. Honorable.
Good afternoon.
This is Samuel Strength before the court, 24 CF 2555. Just for the court's awareness, Mr. Strength observed drug court last Wednesday. He has already been approved by treatment, and we are hopefully getting an answer from the state soon. It sounds like possibly next Wednesday could be a plea in the drug court.
All right, so we want to just set it for status on 8/20 to see what happens.
That would be great. Status on 8/20.
All right, status on 8/20, and if he's already pled in, then it'll roll off the docket.
Thank you, Ms. Yeske.
I show his denial's already entered.
You can deny it again, though.
We can further deny the violation.
We'll deny it again, just to be sure.
Good.
Just deny the violation.
Double denial day.
Double denial.
Sentenced on 7/16, this is a new.
Okay, so we'll enter a denial. Sorry about that.
Thank you.
Do something wrong?
Yeah, no, you're good.
No, we're just being sure that Madam Clerk knows, we want to be sure all the details are done because you were just being certain.
Thank you, Mr. Your Honor.
You said it's 8/20 now?
Yeah.
For status.
You're good.
sure? Are you sure that's?
There's a couple more
I
I
show-
have on the
I
docket.
show, did we take care of Knoll?
Kevin Knoll is represented by Mr. Cochran, 26 CF 761. I believe Mr. Cochran asked for him to be taken off of the transport. There's still depositions that need to be completed. I see that it was on the docket for change of plea, but I think we just need to leave that on pretrial,
Okay.
9/14. I believe the state is aware.
And then I
Yes,
got
sir.
McInerney, but we're leaving him to 1:30, right?
Correct. Nigel Fryer, we were going to come back at 1:30 as well with Mr.
All right,
Cochran.
and then Dennis Hunter?
We saw Mr. Hunter. We
that's
set it
right,
over
cross-
possible drug court next week, so we set it on to 8:20, no subs.
Okay.
The only one I have left for the morning docket is Zachary Rogers. There was an amended motion to correct court records. I think filed by Mr. Patel.
I believe I signed that order. So. Rogers. Yeah, I signed those orders. All right. And I don't see anybody here for 1:30 other than Mr. Simpson, who's come and gone, right?
He did come and go, and that's concerning, because he was supposed to stay and fill out his...
No, he did. He
Oh,
came back,
did?
yes.
Okay, good.
And we gave him a new court date.